and then I'll open it. Right. Good evening, everyone, and welcome to our Thursday evening seminar. Tonight, we're going to be looking at novation and construction contracts, and leading us through this maze will be Mohammed Haque, who is a barrister, consultant barrister, adjudicator, and quantum expert for Fletcher Day. And as you can see on the screen there, all his details. As always, if there's something you'd like to ask Mohammed, please feel free to use the chat or Q&A facility in the bottom toolbar, and he will happily answer these questions at the end of the presentation. Alternatively, if there's something you'd like to know but don't want to ask, particularly in an open forum, you are welcome to email him, as we said, mohammed.haque@fletcherday.co.uk, and he will answer those queries for you. Okay, without any further ado, it's over to you, Mohammed.
Thanks, Julie, and welcome everyone who's joining this evening webinar. This has been a webinar I've done a few months ago, but of course, at that time we were silver Shemmings. But however, every time you do something, again, you do it or try to add something better. So if you are someone who's attending for the first time, it'll be good. If you're doing it for the second time, I've tried to accommodate some of the questions that were raised on my earlier presentation. And a couple of guys, they've continued to sort of ask me questions through via email, which I've responded to. So I've just added those in this presentation. So my usual fashion of any talk, any lecture, anything, I ask myself and the audience a simple question: what is it? So tonight we're doing novation, of course, in construction contract. For obvious reasons, I'm not going to let you know or try to explain what a construction contract is, expecting that you at least know that much. But of course, the word novation is nothing to do with the French word novo, meaning the sky. It's to do with bringing a new party in an older relationship. It's something like if a couple decides that they want to bring in a new partner in the conjugal life, of course, not a kid, a partner in the same sense they were earlier. The results can be predicted very easily. You cannot expect all the older parties to remain as is. One of them has to go away, and the new one will take the role of the one who has gone away. That's basically is a novation. It's the process through which it's done is called novation. You've seen it many times, maybe in movies and other places where people fight a lot before this occurs. But in the real world of construction contracts, you don't have that much fight before it occurs. Why not? We'll see it this evening. So novation is nothing but a contract. In a contract, you have two parties, as always, if it's an English contract. And through the process of novation, which is another contract, one of the parties of the older contract, so to say, will drop out, and a new party will come in onto the shoes. So it's a substitution process from one party to another. There is another alternative available, but if the same thing is thought of for various reasons, one party may not continue, and then they want to say goodbye. And it's not, as I say, it's not a love and hate relationship. It's only a contract in whatever construction and other sectors. So the party can simply assign the contract to someone else. But the problem is, historically, a common law, even if you assign your contract, you are still obliged to the original contracting party. So it's like only the benefits can be transferred, but the burdens cannot be. Now, it will be fruitless if you want to wash off your hand from an old relationship. Then that you should be allowed to. Well, if there is already a child of the wedlock, then that's a different thing. You'll carry it on, and we'll see similar situations will come off and on in our examples. But if not, they should be able to clearly wash their hands off. So to answer this, a company law practice has been borrowed, which is for the construction, pre-incorporation contracts, and it's well understood in company law that earlier two parties entered into a contract, and then one of the parties' status been changed, and so the new party has become a company limited. So the same contract with the promoters you have with the company to be registered is then redone by taking the company as a party, and that's called novation, of course. That concept is borrowed in other sectors and sections of contract law, and we have novation widespread everywhere, whereby if one party wants to go away, he or she can simply walk off by having a novation agreement, provided that person can find a new one to join the regional contract. And how that's done, it's a doctrine of contract, so parties are quite free to sort of draw their fate and draw their terms and conditions and procedures, how they're going to do it. But we will try to take a stock or an account of how these are done normally. Now, as I said, how these are done normally, I would give you an example first. That, for example, a scheme or a project has been conceived by the ultimate client, the user or the employer. And what happens? For a small house to be built, and the person who start thinking to build one meets guests and friends and all, and say, look, Jones, I was thinking to build or an extension or demolish my existing property and rebuild and whatnot, and I don't know where to start. The advice, some bystander, officious bystander, always you'll find everywhere, would tell the employer, would-be employer, that call an architect. Okay, so that's for building projects, but in other places, for other types of contracts, you go to engineers and they manufacture a whole plant maybe to install, erect, and all these. So that's that type of thing in different jurisdictions happen. And the employer, what they do, employers, what they do, they appoint their architects. So the architect's first job is, just assuming that it's a building project, just not making complicated, the architect's normal fashion is to listen to the employer and then go away, take things which will allow them to dream of the project, and then come back with a brief, that's the stage 0, and then start sort of developing the design. And it so happened that for one reason or other, the employer thought it's getting too complicated for him. So he decided that, okay, enough is enough. You have done a lot, so now you tender it out. Let there be a contractor, and the contractor will not only build the place, I will let the contractor to oversee your appointment, the architect, and of course, architect in the process appoint other professional designers and report writers, tests conducted, various sorts of things come in, ground condition report, the steel structure reports, and all these needs to be supported, drainage and other utility services to be designed. So it's not only the architects, so many other different people, the mechanicals and electricals come in, to design part by part. And then the employer starts thinking, hang on a minute, I'm managing so many people, and then I'm going to manage the contractor. It's too much. So what he does, he can say, look, I go and be the contractor's consultant. Okay. Now, if the same group doesn't have to become the consultant's, the contractor's consultant, then there's no innovation involved. It could very well be that the employer tells the contractor that I have had enough. I've already been managing these people. They're a fantastic group of people, but management is a headache for me. And please, do this on my behalf, manage them, get the rest of the design done, and complete the scheme. Now that's we call design and build, or we call it contractor's design portion. Okay, whatever way we call it, that's what it's happened. Now, as I said, there isn't any legal requirement that the original consultants remain as the consultants of the contractor to develop or finish or complete the designing process up to the end. There's no such legal requirement, but convenience demands so, and also occasionally the funders demand so as well. It's because, if the designers have done the job right from the day one, they have a good understanding of the project. And by the time the contractor is appointed, they will have insights of the project that is really valuable. And none would like to, and that's to get rid of them. And that's the reason the traditional JCT contracts, they always keep the design team separate from the construction contract, and they are in contract with the employer, nothing to do with the contractor, and they supply all the designs on behalf of the employer to the contractor, and the contractor is headache free. He just constructs the scheme and completes it as per the owner wants. However, as I said, owners could think of not taking too much of an obligation, and there are other good reasons of shifting risks and all. So they might want the contractor to take the responsibility of the design, and in most likely cases, in scenarios like this, the original designers are still kept, and so the contract which came in first between the employer and the architects and other designers are then novated to the contractor, who enters into a contract for constructing the scheme with the employer. Simple as that. I'm repeating this because if it's new to you, that the employer appointed a team of designers, including the architect, or first the architect and the other designers, and then with each of them, either through the architect or directly himself, the owner employer will have contracts for the professional services. Then when it becomes tenderable, when the scheme becomes tenderable, it's tendered, and a contract to construct is entered into as the main suit in any model, form, or bespoke between the employer and the contractor. And in these cases, if the contractor takes on responsibility to design, then the original design team, if it's a factual thing, it's not a legal requirement, if the original design team is chosen to become the designers of the contractor, you can either assign the job or you can use Novation. Substitute in the first contractor the employer's name out and the contractor's name goes in, and the other party, the consultant, remains the same. As simple as that. This is the most practiced novation in construction industry. And if you are a consultant, you need to know what your rights and duties are, how you should play the cards while the liability goes on. If you are a contractor, you should know the same. If you are an employer, you should know the same. Okay, so I have just stepped it down here so that you understand how things work in reality. And of course, even here, I will get back to this point later in another slide. Even in a scenario like this, there are two possibilities. You don't have to do novation in its traditional sense, which makes the contractor liable. I'm not considering assignment. Assignment only transfers the benefits, not the burden. It's a traditional novation agreement which makes the consultant liable to the contractor from day one of its contract obligation ab initio for the period beforehand, and it's vice versa. Okay, that's one way of doing it. The other way of doing it is consult switch. Just bring the contract to an end. Employer can say that, okay, fair enough, I'm not anymore with you in a contract, and for me offering you and securing you the contract for the rest of the part with the contractor, that's the consideration. You agreed to relieve me of anything. Okay, and then a separate fresh contract. It's not a substitution and a tripartite contract. It's a fresh contract being entered into for the remaining jobs by the consultant and between the consultant and the contractor. So that's also possible. So assignment is not novation. Even if novation, there could be one or two types. One is the novation of ab initio, a term which is from Blyth and Blyth Carillion become more popular, and the alternative is consult switch, and I'll get back to this later on once more. Now, novation versus assignment. Let's just try to get the numbers down. We have scenario explained, that the employer and the designing team has one or more contracts. The employer and the contractor has a contract, and then the employer wants to go away and wants the designer team to be in contract with the contractor. So that's the scenario we are considering, and we're trying to understand the rights and obligations of each party, meaning the consultant, the employer, the contractor in a scenario like this. Of course, the alternative that's possible is the employer assigning the rights under the contract to the new contractor, the new party. So what are the differences between novation and assignment? As I say, the assignment only transfers the rights and the benefits, not the obligations and the burdens. Novation transfers both rights and obligations. These are the fundamental difference between the two processes. Legally speaking, assignment does not require any consent because it keeps the original person liable anyway. So if I say that from today, don't report to me, I'm the employer, report to my wife, for example. What's the difference? If I say, don't report to me or my wife, report to the contractor. I still remain liable to pay the fees and everything. Okay, so the benefit goes to the contractor, but the consultant, the original party, i.e. the employers, remain fully responsible. And accordingly, what's the point of seeking a consent before taking an action like that? However, that's the legal position. Normally, in every single contract, you will see an in-construction contract, assignments are not permitted without any without any clear permission, which is normally stated that will not be withheld unreasonably, but assignment is not without permission or advance permission. That's what normally it expressly agreed in any construction contract. Now, just because legally it doesn't require the party assigning to take consent from the other side, that doesn't mean that the practice will not require so, because contract is a contract, the parties are free, and that's added anyway. So on the other hand, a novation always requires the consent of all the parties. So if you want to novate, the responsibilities of the designing team to the contractor, you have to have a consent from the design team. The employer must secure this, and from the contractor. Now, this can be done at the time the employer is proposing the novation, but it can be done right at the outset. Again, I'll come back to this in a later slide. Now, a novation is a rescission of one contract and the substitution by a fresh contract. So the older contracts dies, divorced, separated, no more a couple, and a new one comes into life. And so there is a fresh relationship between them. However, you carry some, if you carry some, if there remains some, then you carry some. Whether you can take the partner as that partner was right at the beginning, or you start your life afresh, are the different types, of options available. But always in the new relationship, new contract, the parties are new. However, they do not do anything new. They carry on the original obligations of the original contract as if they were, if it's a novation ab initio, as if they were parties to each other right from the day one. And then I try to describe, what novation is normally, what we refer to when we talk about novation in our industry. I think I have, okay, I need to discuss the bullet point number 4 I was referring to earlier. That's a consent. When to take the consent from the designer, a professional, as well as a consultant, whatever name you call it, or from the contractor. Time is when the employer enters into the contract with the architect or the consultant or the designer or any other professional. He needs to take a consent. That's the safest way, because if that person did take a consent at that time and then changes their mind, you might think, oh, why does it happen? It does happen. I've seen it quite frequently that an employer thinking, and especially for the residential employers, smaller contracts, they start thinking, okay, I'll do a minor works contract, and then changing mind to do an intermediate one, and then changing, no, it's too much of a hassle. Let me hand it over, everything to the contractor in a design and build. It's not impossible. It goes on so many times. So if initially the project started with a thought process of either a minor works contract or an intermediate form, then you change your mind. Then it could be that when you were appointing the professionals, you were not thinking sometimes, employers think, and the architects also think, I've seen, that to keep things simple, a manor works is good enough, although the heavy sort of demolition and rebuild is involved. But they think as such, and what then happens, after a while they realize that it's too complex, so they switch on. They plan initially that way because they think that's simpler, but no, that's not the case. So in such a case, it could very well be that the contract between the employer and the professional never referred to novation. On the other end of the road, you got the bigger ones or professionally advised ones, and that's the correct way of doing it, is to include an express term into the original contract with the professionals that your services may be novated to a new party who is going to most likely be a contractor, or make it more wider, that tag along, drag along, or forced to be novated, and you don't have any choice to say no. And then also to keep your things more secure, what the employer can do, and it helps the consultant as well, to add a template of a novation agreement, so that when in real time the option is decided to be exercised, it's just a matter of formality that this has been done. And don't forget, if you're the employer and if you want to do this, don't forget to bargain a similar term when you are entering into the construction contract with the contractor. The similar express term and reference to the template and submitting the template to the contractor is something you must consider when you are entering into the construction contract, so that if you decide to do so, you can simply carry on and no one can stop doing so. So what I'm saying here is, employer be aware, caveat employer. I don't know what employer is, how employer is said in Latin, but this is what I'm saying, that all you employers, be concerned and careful when you are entering into a design contract with the designers and the professionals. If you want to switch them or you want to novate them, and there's no harm in securing that consent at the time you're signing the contract with them, and then send them a template as well, so that you the whole process becomes very easy. Similarly, you go to the contractor when you are entering into the contract with the contractor, and tell them the same term, include them in your contract. So it just becomes a process and nothing else. All right, so each party attempts to secure the respective position. So as soon as a bargain starts, you see, the consultant with the employer, and if it's well managed, as I say, the employer will throw to the professional consultants that, look, I'm going to do this, okay? And the template is set. Now, what should the consultant think of? The biggest practical example, I'll not go to unnecessary legal complications. The biggest practical example I've seen was in my life, where in a hugely project contract, I think it was, I did dealt with more than one with them. That's why I'm a bit confused which one it was, but I think it was an offshore oil and gas mine building contract. And the consultants agreed with Shell UK to provide the project construction support. And then later on, Shell decided to offload its interest into that project to a company called Cairn Energy. No disrespect to Cairn Energy, I worked for them. It's a wonderful company, I like them. I kind of was involved in the early days as well. But I was advising on that particular occasion advising the professional team and also other partners. So what happened? I said, look, you are going away, but the person you are handing over to is not of your standing. At that time, I'm talking about, I think 1999 or year 2000, Cairn Energy was very small. So I said, look, it's very, very different for us, because although we were consultants, I was working for a consultant, but it was a multi-million dollar consulting fee project. So we said, look, it's very different that we were given the contract by Shell. Now, advantage I took was the template of the Novation agreement stated that the Novation, the consultant will have the right to refuse the Novation if the contractor or the new party was not of equal standing as the original party to the contract. Well, I'm saying this because I'm that poor lawyer who drafted this paragraph when the consultants agreement was created, and many people shouted at me that, you are doing a nonsense, you don't need, just a Zawabi case, I was personally involved in that as well. And many said that, we have done it so many times, why do we need to have this? But I said, look, I feel like this. And that saved the consultant, because then we could take a collateral warranty from Shell that in case Cairn cannot execute the project, we'll get our fees and losses from Shell. Just I gave this example so that you understand how you should start digging the ground early if you are a consultant, and how you should ensure that later on you don't want to get into your trouble. So that's from a consultant's perspective. Obviously, the employer, what and how he wants and why he should try to do something to secure something. It's simple that if there were mistakes into the early part of the work, disputes will later on come, and we'll see a case in a minute, who is responsible for that? So the employer would like to wash their hands off totally, and want the contractor to take the responsibility of mistakes in design from day one, which we call novation ab initio. And even sometimes, additionally, take a warranty from the contractor that they will not bother if there was a mistake. They will not bother the employer, although the mistake relates to a time slice which was earlier than the Novation agreement. But if they want to exclude it, Hadley Byrne and Held and Palmer, House of Lords, as it then was, 1966, emphatically declared that in a commercial contract, you can exclude your liability, no matter how. And it's not a consumer. If it's not a consumer contract, the tests of reasonableness under the unfair contract terms, it's very easy as well. So the employer needs to and try to kind of make the consultant and the contractor responsible to each other from the day one, and yet keep the benefit of any loss been suffered due to such a mistake, and then recover it from both the parties. So that's something from the employer and the consultant's perspective. There are funders as well, and you'll see that in standard forms around the market, there are forms for the funders as well. So the funders may want to seek their position. And finally, of course, the contractor's best bet is that he keeps the employer liable and the consultant liable to him for any mistakes into the professional services prior to his engagement. So you can imagine what a fight it is. And depending on who you are, you have to sort of play your cards. If you're the consultant, I have one, I know PI, how important it is. So you got to, even to get a quote or not to get into trouble later on, be careful, okay? Be careful. So everyone involved in it, and the normal fashion, how you resolve it is by seeking appropriate warranties from the other parties. That's what is in practice. Now, what about if the consultants are novated to the contractor? What about conflict of interest? Because up to today, you were working with a mindset of doing the best for the employer, and then you are working for the best for the contractor. You might say, look, well, I'm a professional and I just believe in the best thing. It's not always so. For example, if there's a range in a specification, if you're acting for the best interest of the employer, and if you're a professional, you'll obviously opt for the best within the range. Or you'll draw the spec in a way that will give the employer the best option. Now you have already done so, and then it's a design and build, and then you are setting the specs and the calculations which are compliant with law, regulations and other things, but may not be the best in the range. How do you think that you can act continuously for the best interests of both the parties? But once you are appointed, subject to the limitations of your professional code, you need to act for the best interest of your client as well. So there could be a conflict. And that, of course, everyone has signed up to it, so there's less chance. But if you are a consultant, you should sort of insert things which saves you, that your judgment will be treated as the best judgment in that sense. And whatever you do cannot be questioned or cannot be the basis of a claim in negligence or in conflict of interest. I always suggest my clients to sort of, if they're consultants, to protect their position like that. Example, learn your lessons from Blyth Blyth and Carillion construction. It's SLT, you can understand it's a Scottish case, and where the contractors attempt to recover losses for pre-novation breach of the designer failed. Why? Because the contract between, simple, I'll not make it complex, and I do not believe in what Lord Esser said and what the factual peculiarity of this is. There was a builder and there was a fairy tale. We don't need to know and understand this. At least none who's listening to my talk. I had to, and I know how difficult that is. So let's go to the point that the reason why the contractor failed to recover the loss was that contractor was made responsible right from the beginning to the employer. And the consultant was only responsible for the mistakes in the designs to the employer. So it's like a mathematical equation. The law lord who delivered the judgment at the court session say, look, in each way, the contractor is responsible. So why? Consultant was responsible for the pre-novation part to the employer. Contractor was responsible for the pre-novation part to the employer. So the employer could show and wash their hands off. If you sue the designer, he will say, I'm responsible to the employer. Who are you? Well, solution could have been very easy, employer suing the consultant because he remained liable. under that contract. Alternative solution, you go to, if it is an ab initio type novation, you try CIC model form. They have brought in a very nice balance. There are others as well in government portals, in City of London, Law Society model. There are so many models there, but my preference is CIC model. You got to buy that form if you want to save yourself, but that's the solution where it has been provided what to do. Alternative solution, of course, is not even agree to innovation, go for consult switch and take warranties. End of. For different periods, employ different tactics and make sure you follow the appropriate contractual procedure to ensure your position. Question novation by conduct. We're talking about deeds, collateral warranties, express terms, tripartite contract. How can that be done by conduct? Well, we had someone great named Lord Denning back in 1969. He found a scenario where he said, look, just because there was no written document, I can't find a requirement in English law. In company law, there is a requirement that if you are doing something regarding the pre-cooperation contracts, it has to be in writing. But other than that, I can't see any formality requirement anywhere. It's a practice, fair enough. But no, it's not needed. If it can be shown that by conduct, parties did enter into a novation agreement, that's fair enough. We don't need to. But what conduct will be sufficient is a question of fact, and it will vary from case to case. You might think, okay, Lord Denning is long dead, and it's 1969. We're in the 21st century. We're in 2021. Hang on a minute. Enterprise Managed Service Limited, the McFadden Utilities Limited, only in 2009 decided again that English law never prescribed, other than in specific situations, like, as I said, pre-incorporation contract novation in company matters requires a particular form, and there could be others, but in construction industry, there's no such requirement. English contract law can always be applied in informal situations where it's done by conduct. So do not start arguing in a big way that because there was no written agreement, there was no novation, provided you can sufficiently prove that all the three parties agreed to novate the contract from one to the other. However, that's where you start having difficulties, because since it's a conduct, unless very unequivocal, wide language is used among the parties in oral discussions, it's difficult to establish. Sometimes it's an evidential difficulty to prove that all the existing responsibility of a contract has been novated to a new party. So it could very well be some of them were discussed, and a court will decide that only those rights were novated to the new one. The earlier one still continued, as maybe it's only an assignment. So at least the burden remains with the original contracting party. If you, however, discuss clearly to complete a novation, and a procedure has been discussed as well, and then you do not follow the route, then there is no novation at all. Even the facts might give, although the fact might give rise to a conclusion of an assignment, no novation. So it's contract law, and the party's intention is very important. So you got to find out whether the parties were conducting themselves in a way wherein they were contemplating an informal novation without anything in writing, or they were discussing the possibility of a written novation, and which they have never completed. If the latter is the case, there's no novation. The earlier is the case, although there is no written agreement, there might be a novation. Repudiatory breach in novation, or in other words, can novation be a repudiatory breach? Yes, it can be, if you, let's say, are required to follow a notice procedure before you get the final consent, and without doing so, you just go and sign a novation agreement, or try to impose a novation agreement where you didn't take a consent earlier. It could be a repudiatory breach. But just because you want to substitute a party to a contract, if your notice says so, it may not be a repudiatory breach if the court decides that what you have been trying to do was a mere assignment. You're quite free to, unless contractually barred, legally you are quite free to. So whether your attempt is or isn't a repudiatory breach depends on whether you are trying to impose a novation or you are trying to just complete an assignment. Finally, I'm a man of adjudication. If you have ever attended one of my earlier ones, you know I'm for adjudication, of adjudication, by adjudication. So how can I go without saying something of the relationship between novation and adjudication? Remember, there is one case already where it says that unless there is a novation, you cannot bring a claim under the original contract. In other words, if you are not a party to the original contract, you cannot. Okay. The argument of novation by conduct failed in that no, you can't. So no new party to the contract can bring an adjudication. So if you are bringing an adjudication under the original contract and you are a party only to the new contract, your case will fail. Similarly, if you are bringing one under the new contract, and if you are only an party to an original contract, your action will fail. How can you save it? Very simple. You can join hands together and bypass this rule, because in each of the two contracts, the original party retains the right to adjudicate. Alternatively, you should adding that right in your contract. So under your contract, you have the right to adjudicate under the other contract. So it becomes a dispute under your contract. And I think that's all for today.
Thank you very much, Mohammed. As always, very interesting points there. If anyone has any questions, now is the time to ask them, either via the Q&A or the chat facility in the toolbar, or as we said earlier, if it's something you don't wish to ask on open forum, email mohammed.haque@fletcherday.co.uk. We are back next week. We have a busy week next week. We're seeing Mo twice. On Tuesday, we have a case in point live at 6 o'clock. On Wednesday morning, we have extensions of time and proving delay with John Sharp. In the evening on Wednesday, 6 p.m, we have what is concurrent delay with Richard Silver. And then finally, Mo wraps up the week for us again with the next in his changes in construction contracts, evaluation and other implications, which is a series he's been doing for the last couple of months. That's on Thursday at 6 p.m. If you would like a place or to be able to log into any of these, please email us on seminars@fletcherday.co.uk and we will book you in. Other than that, it remains only for me to thank you all for turning up this evening. Thank you, Mohammed, as always, for your sharing your knowledge and wisdom with us. And we look forward to seeing you all online again very soon. Take care, everybody. Have a good evening.
Bye-bye.